Is the US Supreme Court's ruling on abortion a step backwards or a step forward? Let me make 10 points. Point 1. An abortion is a procedure to end pregnancy, sometimes known as termination of pregnancy, and the pregnancy is ended either by taking medicines or having a surgical procedure. Point 2. The statistics show that millions of women will be affected by the US Supreme Court's ruling, disproportionately impacting on young women, women of colour, and women on low income. In the US in 2019, there were about 630,000 abortions reported. 57% of abortions were women between the ages of 20 and 29. Black women received more than a third of the country's reported abortions. They make up 13% of the US population, and 49% reported abortions are US women below the poverty level, according to the surveys. Point 3. There are challenging, profound moral questions about abortion, whose answers sharply divide people, not just in the US, but around the world. When does human life come into being? From conception, from detecting an unborn's heartbeat, when an unborn is viable outside of the womb, or from birth? Does a woman have a fundamental right to control her body, to choose to have an abortion? Does a woman have a right to abort a fetus conceived by rape or incest? Does the state have a right to deny or restrict a woman's right to choose to have an abortion and force a woman to go to full term against the pregnant woman's wishes? Point 4. How do you answer these complex, sensitive, moral, political, and yes, legal questions that involve issues like personal liberty, bodily autonomy and privacy, as well as issues about preservation of life, protecting the vulnerable, and the role of the law in whether it can and should intervene to protect? And if so, who or what is the law protecting? A woman's right to choose or the unborn's right to live? And the US Supreme Court in 2022 was asked to consider 2 questions. 1. Does the written US Constitution confirm whether a pregnant woman has a fundamental and constitutional right to terminate her pregnancy? And 2. Or should abortion laws be decided by each state, that assembly of people who have been voted in at the ballot box? Point 5. As Justice Alito in the 2022 Supreme Court ruling stated, for the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. In other words, up until 1973, there was no broad constitutional right for a woman to have an abortion, and there was no mention of abortion in the US Constitution, according to this argument. Consequently, each state decided its own abortion laws. At the time of Roe in 1973, 30 states prohibited abortion at all stages. Point 6. That's why Roe versus Wade in 1973 was such a landmark ruling, because in a single ruling, the Supreme Court struck down laws in most states that banned abortion except to save the life of a mother. In this case, Norma McCorvey, using the alias Jane Roe, challenged the criminal abortion laws of Texas, which made it unlawful for her to have an abortion except in situations where the mother's life was in danger. Defending the anti-abortion law in Texas was Henry Wade, the district attorney of Dallas County Court, hence the name Roe versus Wade. The majority ruling in Roe versus Wade decided that a woman's right to terminate her pregnancy was, in fact, protected by the US Constitution. Justice Harry Blackmun in Roe, rooting the opinion on the interpretation of the 14th Amendment, guaranteed that government shall not deprive any person of life, liberty or property without due process. That right to liberty, encompassed according to this ruling, gave a right of a woman to choose abortion at an early stages of pregnancy, and a state's abortion laws which denied her of that right infringed on her right to privacy. The case also created the trimester system, allowing an absolute right to an abortion in the first 3 months of pregnancy, some government regulation in the second trimester, and states to restrict or ban abortions in the last trimester as the fetus nears the point where it could live outside the womb. Roe versus Wade also established that in the final trimester a woman can obtain an abortion despite any legal ban only if doctors certify it necessary to save her life or health. Point 7. Far from settling the issue of abortion, Roe versus Wade divided opinion from the beginning. The dissenting opinion of Justice Harry Rehnquist raised concerns about the majority opinion in creating the trimester system and challenged the existence of an absolute right of a woman in the first trimester to an abortion was found in the Constitution. He believed that such rights should be determined by lawmakers, not judges, by states, not the US Supreme Court. This minority view, its criticisms and reason hadn't gone away. Point 8. In the 1992 case of Planned Parenthood versus Casey, the Supreme Court abandoned Roe's strict trimester framework from Roe versus Wade, but maintained a woman's fundamental right to choose to have an abortion before viability. The case re-emphasized the right to abortion based on liberty and privacy protected under the Constitution, that is the 14th Amendment. Point 9. Now fast forward to 2022, Dobbs versus Jackson Women's Health Organization in 2022, 50 years after Roe versus Wade. Here the Supreme Court was asked to rule on a Mississippi Act which made it unlawful to perform an abortion after 15 weeks. Dobbs, the state's health officer for Mississippi Department of Health, defended the act on grounds that Roe and Casey were wrongly decided. The majority opinion of the Supreme Court agreed with Dobbs and completely overturned the ruling in both Roe and Casey. The ruling said Roe was on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors, and those errors do not concern some arcane corner of law of little importance to the American people, rather wielding nothing but raw judicial power. The ruling opinion continued, abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey abrogated that authority. The court overrules those decisions and returns that authority to the people and their elected representatives. In short, the Supreme Court ruled it is not for the courts to decide abortion laws, but each individual state. Point 10. And just like in Roe versus Wade, there was a dissenting opinion. The 3 dissenting justices wrote that they had done so with sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection. But what do you think? Will this ruling now settle the argument in the United States? What ramifications will this ruling have in the United States and elsewhere? And is the US Supreme Court ruling in 2022 on abortion a step backwards or a step forwards? Feel free to comment, follow, like and share.